Stand, please. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-1256 et al. Central Hudson Gas and Electric Corporation et al. Petitioners versus Federal Energy Regulatory Commission. Mr. Tompkins for the petitioners, Mr. Kaiser for the intervener for the petitioners, Mr. Perkins for the respondents, Mr. Strauss for the New York State Public Service Commission, Mr. Tabat for the respondent interveners.
Good morning, Mr. Tompkins. Please
Morning.
proceed.
May it please the court. Jason Tompkins for petitioners, the New York transmission owners. With me at council table is my colleague, Andrew Tunnell. I'll endeavor to reserve 3 minutes for rebuttal. Transmission owners must own and operate system upgrades required by generator interconnections on a nonprofit basis. Due to a 1,200% increase in the number of generator interconnection requests within NISO in the years leading up to this filing, the transmission owners requested from FERC the ability to earn a return on new upgrades going forward. They did this through 2 alternative filings that each independently would lead to the same end result. The first was a Section 205 filing, a request to amend the tariff. The issue before this court on that order is one of contract meaning. Section 310 of the ISO agreement reserves the transmission owner's rights to seek costs plus a reasonable return on investment. The easiest way to determine whether the transmission owner's filing fell within those words is to look at exactly what they requested. Joint Appendix page 13 shows a red line of the tariff amendment, which requests, and I quote, a facilities services agreement that provides for the transmission owner's recovery of its funded costs plus a reasonable return on investment. Thus, by the plain terms, what the transmission owners requested falls precisely within the same terms as what they reserved in the ISO agreement.
I ask you about that 310 issue. You have not put a dollar figure on any past costs that you're trying to recoup. And you have not put a dollar figure on any future costs that you're trying to recoup. Is that, I know you may think that that isn't important, but is that correct?
We did put a dollar figure on some past costs.
Where is that?
Mr. Novak's testimony, where he discusses the 5 types of risks that the transmission owners are subject to by ownership of all transmission facilities, including the system upgrades. He gave examples of NERC penalties, of Public Service Commission penalties and negative rate adjustments, of cybersecurity penalties. And he did put a dollar figure on all of those things. Those are at Joint Appendix 108 through 116.
Okay, if I'm trying to figure out the difference between a risk and a cost. And imagine I have an air conditioning cost and there's a heat wave, my air conditioning cost goes up, the expense goes up. But we wouldn't call the heat wave a cost, right? We would just call it a cause of the cost. You see where I'm going with this?
Well, that's correct. And I think one of the examples given in the testimony from Mr. Novak of that type of risk is the flip side of that, which is instead of a heat wave, a cold snap, like the cold snap that occurred in Texas in 2021. That is a risk that resulted in hard costs.
But doesn't that just illustrate the difference between a risk and a cost? So again, the cold snap is not the cost. The cold snap is the cause of cost. Not every cause of a cost is itself a cost.
Well, that's true. But I think the important thing there is that once those risks come to fruition, they result in a cost that the investors have to bear. And so taking this back to the fundamentals of Bluefield and Hope, utilities, public utilities, are entitled to earn a return on all property used in public service. And investors are investing with acknowledgement that their return satisfies their desire that the risks are covered. And here we have a large category of risks that are not currently covered in the return on investment that the investors are looking at.
So you would call the cold snap a cost?
We would, under this provision, we would say that it is a cost. And I believe that Ameren recognize that these costs, or that these risks have real costs in the real world.
Do you need to win on that point? And that's a counterintuitive, possibly counterintuitive understanding of cost, but it's not a cost, it's a risk. And if you're driving up the risk, you should get a greater rate of return. So you have to account for this problem either through the cost route or the rate of return route.
So two points on that, Your Honor. No, I don't think we have to win on risk being perfectly equal to costs. The first reason is what I mentioned before with Hope and Bluefield. Even absent risks, the Hope and Bluefield established that under the regulatory compact, public utilities should earn a return on their property that is committed to public service. Here, even though they did not initially fund the generator system, the system upgrades required by the generator requests, they were conveyed to our clients, and our clients do own them. It's now their property and it's being used, and they're not earning any sort of profit on that. So fundamentally, it violates the principles of Hope and Bluefield. But secondly, there's also the other part of the 310 reservation, which is return on investment. And that fits very neatly with what I think the transmission owners are trying to do here. They were trying to add these system upgrades into rate base. And return on investment has...
Is that really fair? So it seems to me, what FERC says is that what you're actually trying to do is change the rules so you can make new investments by now funding the system upgrades that you can't currently fund. And one thing this filing reservation provision doesn't allow you to do is change the rules to allow you to make new investments. So where does that argument go wrong?
I believe that's a circular argument. The return on investment would be meaningless if we can't request permission to make the investment.
You can absolutely, well, I think one thing you could definitely do is say, make a filing that says, for investments we've already made, we are not getting a reasonable return on investment and it needs to be increased. But what you can't do, FERC is saying, is ask for permission without getting consent from the ISO under this filing provision to allow you to make new investments.
I think if we were to make that first filing, Your Honor, FERC would say it would violate the prohibition on retroactive rate making. I don't believe that we have the ability to recoup any of the costs or compensation for any of the risks for system upgrades that were implemented prior to our filing of the Section 205.
They say repeatedly in the orders and the briefs that you could make a filing arguing that the risk assessment built into your rate of return is insufficient.
They say we can make a filing to adjust the return on equity component. That is correct. That actually shows, that inconsistency shows why they're wrong about our filing right to begin with. The section you're talking about, the advice, I'll call it, that FERC gave, is primarily in paragraph 69 of the rehearing order. I believe that's Joint Appendix 836. And it states, as Your Honor just paraphrased, that to the extent the transmission owners believe returns are inadequate to compensate them for the enterprise-wide risk presented by owning, operating, and maintaining their entire transmission system, which includes system upgrades, they retain the right to file under Section 205 of the FPA to seek to modify their base ROEs. ROI, return on investment, the words used in the reservation of rights, is a mathematical formula that's set forth at Joint Appendix 8485. ROE is a variable within one of the factors of ROI. So FERC is saying we could request to adjust one component of ROI, the return on equity component, but they're saying we can't adjust the other variable, the rate base. We believe that inconsistency shows that the transmission owners had the filing rights, whether it's in ROE or in the rate base, the filing right was there. The fact that FERC believes it should be in ROE instead of rate base may affect the ultimate analysis if FERC were to address the merits of the proposal, but it doesn't affect the transmission owner's rights to ask for that return in the first place.
Why can't, put aside the question about retroactive rate making, just conceptually, why can't one solve the problem you're facing by adjusting ROE? Your theory is the enterprise is becoming more risky as the transmission owners are forced to undertake all these additional responsibilities. And if they can't expand the rate base, there's more risk and no greater return. You could solve that problem either by expanding the rate base or expanding the return on equity to the people who are bearing the risk.
So I'll say it's possible.
Mhm.
It might be possible to compensate in that way. I'll tell you why we think it's not the best solution. But before saying that, I'll just point out that whether it's the best solution or not, we don't think affects the threshold
Right.
issue of whether we have the right to ask for it. And we wish to have that debate at FERC, but this was a new theory. This ROE theory was brand new in this proceeding. We didn't get the opportunity to engage with FERC on which of those things is best because they rejected us at the threshold question of whether we could even ask for it. So it doesn't affect that, but we believe that the ROE solution is an entire mismatch with the actual risk because ROE is designed to encompass risk related to the rate base. That's why it's multiplied by the rate base to give that return. So adjusting the ROE to account for risk outside the rate base creates a situation where the facility contributing the risk, the new system upgrade, isn't in the rate base. It's contributing zero to the rate base.
This seems like sort of the core issue on the Section 206 claim. And FERC says in its orders that the enterprise-wide risk assessment does exactly what you say it doesn't, that it is a measure of the overall risks posed by the enterprise as a whole, including system upgrades that aren't in rate base. And it seems like you claim the opposite, but I want to know what the basis is for that. Is it anything more than the logic that you just set out? Is there a document somewhere that says the risks posed by upgrades not in rate base are not considered in enterprise-wide risk?
No, at this point, it's primarily that logic because we never got to step 2, even in the 206 order. Speaking of 206, 206 has 2 different steps. We have a similar argument as we have to 205. Step 1 requires that FERC conclude or assess whether the existing rate is unjust, unreasonable, or unduly discriminatory. It's only at step 2 that FERC decides what's the best replacement rate. The problem here is that FERC collapsed the 2 and said, because we believe that these costs or risks can be accounted for in return on equity, we don't think you've shown that the existing rate is unjust, unreasonable, or discriminatory. The problem with that, though, is that whether the risk of future system upgrades can be handled through ROE is that currently it's not. The evidence that we have in the record from Mr. Novak is that our current ROE does not account for the risk of this. And so based on the fact that Ameren concluded that these risks are real and accept the economic logic of this class of risk, and they're currently uncompensated. They're not in rate base and they're not in ROE. Means that the existing
That's the
rate
key
is
question,
unjust.
right? What's the evidence that they're not currently compensated?
Mr. Novak, I can get for,
His
If I have any
testimony
time.
at JA 649 to 650.
I'll have to
That's the one thing that I
confirm the pages on that. If I have any time left for rebuttal, I can
We'll
get that
give you
for you.
time, don't worry.
But yes, Mr. Novak testified that it is not currently these risks are not currently accounted for in ROE. In our rehearing petition, I believe it might be page 14 of our rehearing petition. I don't know the JA site offhand. We also explained that our current transmission rate was developed before the pro forma interconnection system even existed. So it couldn't possibly account for these risks. And so under 206, we believe at step one, because the risks are real and because they're not currently compensated in either rate base or ROE, FERC should have moved on to step two. And then we could have the debate with FERC that you're asking about, Judge Garcia, about whether ROE is better or transmission owner funding is better.
Suppose we agree with you on the threshold waiver question and you win the 205 piece of this. And suppose also that when we think about the 206 piece of this, we agree with you that FERC didn't adequately explain what I'll just call the Ameren problem. Okay, take those two things as a given. They still, in the 206 order, say something else, which is you can solve your problem in the way I was suggesting, which is making a 205 filing to seek a greater rate of return. That would seem to be a live issue on the assumptions I've asked you to accept. Why isn't that an independent and adequate ground to support the 206 order? And put aside the ancillary implementing amendments, just on the core 206 point.
On the core 206 point, I think it goes back to what I said a second ago, which is the fact that FERC believes there is an alternative to seeking it doesn't mean that the existing rate is just and reasonable. And under this court's decision in Amera, Maine, FERC has to make that threshold decision about whether the existing rate is unjust and unreasonable. And for the reasons I stated a minute ago, we believe that FERC's decision that it is arbitrary and capricious and without substantial evidence. We had evidence that they're not currently compensated. And under that framework.
Yeah, it's a weird 206 where you're filing a 206 complaint, attacking your own tariff. I'm just trying to process who has what burden.
It is that
justification.
there were two alternatives trying to accomplish the same thing. If as I said at the beginning, these are alternatives. So we believe that if you grant the petition on the 205 issue, you need not reach the 206 issue, and FERC would have to determine whether the transmission owner's proposed rate is just and reasonable.
I mean, you've challenged both orders, and if you win on 205, we still have to deal with your 206 challenge.
Yes, and we believe both should be vacated and remanded. But I was just pointing out that I think that you could reach one and not the other.
Do we have to deal with the 206 if we agree with you on the 205? Say we agree with you on the 205 and it goes back to FERC and you get to argue with FERC about whether your new proposed tariff is just and reasonable. Let's say you convince them, then that would moot the 206 issue, right?
Yes, we believe it would. We believe you only have to reach 205. At that point, FERC would have to determine whether our proposal is reasonable. And even if FERC's proposal is also reasonable, as FERC has pointed out, there are multiple ways to seek this compensation.
Anything else?
FERC makes a big deal that you don't disclose these risks to investors. Is it true you don't disclose them to investors?
That is not true. Mr. Novak pointed out that the parent companies, the publicly traded affiliates of our clients, do in fact disclose these categories of risks. But recall, these are prospective risks. They're current risks with the smaller portion of nonprofit appendages that the clients are operating. But this filing is prospective only. This was meant to deal with that 1,200% increase that was requested in 2019 that's going to more than double the number of nonprofit appendages within the system.
Thank you. We'll give you rebuttal time. Mr. Kaiser, welcome.
Yes, sir. Thank you. May it please the court, William Kaiser for the intervener supporting the petitioners. FERC's enterprise-wide risk theory creates a dangerous precedent that left to stand will completely undermine the cost of service rate-making models established by the Supreme Court in Federal Power Commission versus Hope. FERC's theory would require investor-owned utilities to own and operate their portions of a business as certain portions of their business as a nonprofit. So under this theory, when a generator decides it wants to interconnect to the system, the utility has to lend its expertise to assess that interconnection, determine what facilities are needed to be built, build those facilities, own those facilities, operate those facilities, maintain those facilities, and do so with no compensation.
I mean, Hope is not a great case for you, right? It says you don't really look inside the black box of how the rate making works. You just make a bottom line assessment of whether the numbers are broadly reasonable.
It does, but Hope does establish a compensation mechanism. And here FERC is trying to take that completely away by denying the utility the opportunity to make the investment. That's how Hope establishes that utilities are compensated, by being able to make that investment. And so here the commission is trying to, with a sleight of hand, deny the opportunity for investment. And so that is why it undermines Hope.
Do you think the only way to solve this problem is to put that investment into the rate base as opposed to just adjusting the rate of return?
The problem with adjusting the rate of return, and I appreciate your question to counsel for the petitioners, is that two things. First, it results in a cost shift. So the ROE, when it is applied to rate base, when a higher ROE is applied to rate base under FERC's theory, it would go to transmission customers. Here we're talking about charging generator interconnection customers for the cost of their interconnections. So it goes to a different set of customers first, but more importantly, it also results, FERC's ROE methodology just isn't fine-tuned enough to be able to pick up the risks of particular classes of facilities. So it's a methodology that's good for adjusting overall risk to a business model as a whole, but not for particular classes of facilities. It's just not fine-tuned enough to do that.
Sorry, so you're saying you adjust the return on equity, which allows you to charge more, the transmission owner to charge more, but that's getting passed through to
transmission customers, that's right. Because under the regular rate making methodology, it goes straight to the ROE itself goes to transmission customers. Here, the New York transmission owners are trying to establish a cost that would go to generators.
I got it. Thanks.
I'm out of time, but I'm happy to answer questions.
Garcia? Okay, thank you.
Thank you.
All right. Mr. Perkins, whenever you're ready.
May it please the court, Jason Perkins for the commission. There was a lot to respond to topside, but I think one of the things that I started out with would be the question about costs versus risks under section 310A of the agreement. So the bottom line question that FERC was trying to answer in this interpretive question was changing the investment rules for system upgrades, quote, necessary to recover all of the transmission owners, reasonably incurred costs plus a reasonable return on investment. And so you, in applying that provision, have to find a reasonably incurred cost. And the word plus matters a lot in this phrasing because it applies to costs that you have to recover, actual dollars and cents, plus any reasonable return on investment that's associated with those costs. So what the commission was doing here was essentially looking to see whether or not there were dollars and cents at issue in this filing. And it was actually a policy-driven filing trying to change who incurs the investment. The ones who actually put money into this right now, into the current system, are the generators. The generators pay for their own facility, they pay for the interconnection facilities, the line that runs to the grid, and they also pay for the upgrades on the grid that we're talking about here, which are integrated with the rest of the system, which are, according to petitioner's own words, virtually indistinguishable from the rest of their facilities. And they present the same risks that the rest of their facilities present. So I think in interpreting these words and understanding what the transmission owners wanted, the real thing at risk here was the returns they were already receiving on the rest of their system as a whole. That's why, that's the concern that a lot of the testimony gets into about negative revenue adjustments and NERC penalties. The profit margin that they already received might be eroded by those things because they can't necessarily recover some of those penalties and some of those problems from their customers. So they essentially need to protect their profits, and that's why they came in to make this particular filing. And FERC interpreted that as saying the problem is maybe you have a risk return mismatch based on what you are currently earning, but that's an issue for the return on investment type of
So
question.
that was my instinct as well, coming in this morning, which is they have a plausible explanation why they have an Ameren problem. And you have a plausible response that you don't necessarily need to expand the rate base in order to solve it.
Mhm.
Okay, but now I'm a little less comfortable with that, hearing two concerns from your friends on the other side. One is that going down that path creates a retroactive rate-making issue. And two is the intervener's point that if you go that route, you're imposing the costs on the wrong set of customers. So what are your responses to those two concerns with doing this through ROE rather than the rate base?
Right. So I think to take the second one first, who the right set of customers to pay for these things.
Right.
The risks are to the system as a whole, and there's nothing in the testimony that says that these risks are distinguishable for system upgrades themselves. I mean, my understanding, not an engineer, but my understanding is if you looked at the system, you took a picture of the transmission facilities they have in New York and you handed them to an electrical engineer, they couldn't tell you which ones were system upgrades or which ones were part of their system. And so there's not really a difference in kind of the risk that's happening here. It's maybe an increment to the overall risk of the system. And the types of things they talk about are the same things they already face today.
And
So
you think that's so, I mean, there's a cost causation principle, as you know.
Mhm. Yeah.
It seems perfectly coherent to say that all of these costs are being imposed by the new interconnection. And so the new interconnecting generator should bear those costs.
Well, I think they do bear the costs in the sense that they are going to be the ones paying for this either way. So the capital costs are going to come from the generators eventually. It's just a question of whether or not a profit margin should also go to the utilities, whether they should be the only ones to provide capital in the end for those types of upgrades. But in terms of why it's fair, I guess, the
Right.
rest of the customer base should pay, there's a general understanding, going back to Order 2003 in this area, that these are facilities that upgrade the grid generally. And so the actual usage of these facilities goes to everyone that takes service from the grid. And so in some areas of the country, you do have transmission customers essentially funding credits back to the generator for fronting the money for this. So it's not unfair for transmission customers to have some cost exposure. In the current system, which the transmission owners don't mention a whole lot, but it is true, they recover the operations and maintenance costs of these facilities from the general customer base. Because again, I don't think that they are determining which facilities are actually system upgrades and trying to have a separate line item for that.
Okay.
So
What about the first point?
the first point again was, sorry.
Let me see if I got it. About the concern if you do this through ROE, it's a retroactive.
In a case
You're
where,
changing the return for old investments based on risks and problems that are happening from this new new upgrade investment.
Right, yeah. So I think, I guess there's two things with that. One is, I don't think there are any examples specifically tied to system upgrades. So we don't have a loss that we're actually talking about. Like a risk is a probability of a loss or a potential loss. So there hasn't been an actual loss that's been demonstrated specific to system upgrades that they've been, had to face. Like their profit margin hasn't been eroded specifically
but,
yet.
I mean, big picture, right? The world is
Yeah,
changing.
right.
They have to do
Right.
large amounts of new upgrades because of this green energy initiative, and that changes things.
And right, I think that changes things. I mean, and adjustment to their previous investments is going to be prospective. But it is hard to see how they are left holding an economic injury, a specific economic injury from this. I think it really doesn't move past the hypothesis stage of there being a problem here. And so while there is a retroactive rate making constraint on what the commission could do in the future, it's not clear that, especially when they haven't valued any risks, if you look at the rehearing order, you see roughly paragraphs 63 through 65. If you haven't actually valued the risks, we don't know how much it's worth to you. And so that's why it's a question of an overall enterprise type of risk, that you get paid for the money you actually put into the system. You don't necessarily get paid for the money that other people put in the system. And that's a longstanding commission policy under contributions in aid of construction agreements that you see reference as well in the rehearing.
You say the risks are hypothetical, but in Council's first answer to my question, he pointed to some penalties in the past that have had to be paid. Why is that a non-hypothetical real cost? Why is that not?
Sure, I think it's certainly a real risk, but again, as the commission was explaining it, it's the type of thing a transmission owner already faces. And so there's already a place in the rate making calculus to take into effect those types of risks, that they might face a cost that they can't recover from customers. Like
I thought his point was that these penalties would not have existed if it weren't for the system upgrades.
So the risk of them certainly exists today because they are applied to the transmission facility base generally. Like all facilities that would be subject to NERC penalties, these aren't different in kind from them. It's just the fact that the system is a little bigger.
So there's some risk today. There was always some risk. They argue the system upgrades increase the risks. You say, well, whether they increase the risks or not, that hasn't been borne out in a non-hypothetical concrete way. And they come back and say, yes, actually it has. We have had these penalties that we would not have had absent the system upgrades.
I mean, I don't think that any of the penalties they actually point to are necessarily tied to system upgrades. If you look at the risk catalog they give you, a couple pages of kind of a summary of what the types of risks that they're talking about, they're not identifying anything specific to system upgrades themselves that have caused that. It's just the general possibility.
Can you point to a FERC precedent that when it's calculating the return on equity, it has considered these types of uncompensated risks, regulatory, reliability, cybersecurity, environmental, operational?
I don't know that there's a FERC precedent that explicitly walks through what those are worth, like, what the values are and why the specific ROE adjustment is being made for that. But they are the same type that we recognize generally as the transmission owners being subject to.
It would give me some comfort if you can give me some precedent where at least that has happened. And the reason is, your argument, I think, relies a lot on, well, these shouldn't be in the rate base, but it's perfectly fine for these to be considered if the transmission owners ask us to add them into the return on equity. But if that's never actually happened before, then that seems like it might be sort of a false promise.
Well, I think we're still in the relatively early stages of this concept, in that I'm not sure that the concept was really talked about or understood much before maybe the rehearing request that eventually led to the Ameren decision. So I don't know that there's going to be a deep well of FERC precedent on this particular issue when it comes to looking at it. And this is really the first case where we got into actual evidence about these types of risks. And we have
all that would support my suspicion that maybe this actually can't be added to the return on equity because it's new because it's new, we don't know. It's an unknown. But your briefings just seems very certain that it can be, and it seems like your argument depends on the promise that this can be considered in the return on equity calculation.
Well, I think as the petitioners were saying, or one of the previous speakers was saying, that the return on equity adjustments for particular risks, it's not necessarily the type of analysis that lends itself to an exact line drawing between one risk and an ROE increment. If we did that, then we would have to have like extremely complex types of formulas that look at each individual risks. And so in general, we follow the HOPE standard, looking at enterprises with comparable risks. You look at their credit ratings, their rates of return, and then you look to see where these companies should be in that mix. And so we have to look at it on a company-wide basis. That's how they raise capital. They don't raise capital for particular facilities. So that's how the system and the economics actually work for the companies here.
If I can kind of, yeah, sorry.
No, please.
Zoom to like 10,000 foot level. But it does sort of inform a little bit of my skepticism about FERC's promise that don't worry, we're not going to let you put it in the rate base, but we'll probably let you put it in the rate of return. Ameren strongly suggested that generator funding is unjust. Didn't go all the way there, but it strongly suggested. And then American Clean Power didn't do anything to suggest that transmission owner funding is unjust. It said, there's a discrimination concern that was raised and it wasn't reasonably explained why that concern wasn't legitimate, but it didn't kind of put any faith in the discrimination argument ultimately being a winner on substance. And so coming out of those two decisions, Ameren and American Clean Power, I would have guessed that FERC was going to go with transmission owner funding when it was at issue. And if it was going to make the ISOs across the country uniform, it would make them uniform in favor of transmission owner funding. I think there's been a show cause order that suggests the exact opposite is what FERC has decided, that they're going to abandon transmission owner funding, which again, Ameren came pretty close to saying is required. And American Clean Power didn't do anything to really criticize. And they're going to impose generator funding, which Ameren came pretty close to saying is unjust. I guess coming out of Ameren and American Clean Power and coming out of FERC's arguments in American Clean Power, I'm surprised. And that surprise leads to some skepticism.
Okay, yeah, no, I hear you. I think that the way that we understand the Ameren case, and we described this in the complaint order, I think it's paragraphs 31, 32, is that it recognized an argument that FERC failed to respond to. And so we had to take that argument seriously. And in this proceeding, there was actual evidence trying to put meat on those bones. To determine whether or not.
Recognized and laid out in some detail and quite colorfully by Judge Silberman.
Right,
I have the
right.
same reaction, Judge
Right,
Walker.
but if you look, at the, and we're not trying to refight the Ameren order because or the Ameren proceeding, because we understand that these are serious concerns that the commission has to take seriously. That's why it's doing it in this case, and it's looking at some of the similar issues in other regions as well on an ongoing basis. But the issue with treating Ameren as determining the issue generally is that there were some assumptions built into that analysis. One of the assumptions being that the risks and the size of facilities are material enough that it creates economic injury to the transmission owners. That's a provable case. That is susceptible to real world facts. And so I think it's reasonable for the commission, especially in line with this court's 206, section 206 cases, to expect there to be some kind of real world evidence of a problem. And I think it states a fine hypothesis, but one of the things, and if you look at the dissent in Ameren, it basically says there isn't a whole lot of evidence in this record to say it's actually possible yet. And then if you look at the dissent on the Ameren rehearing order from Commissioner Glick, it also says there's not really a whole lot of evidence of this. Then in this case, you get an actual look at the evidence and it doesn't value the risks. It doesn't say that they reported these particular risks to investors. And we don't get a clear sense as to what the actual dollars and cents problem is for the transmission owners. So we were treating it as an issue that they can bring back to us in the sense of needing a more fine-grained return on equity analysis if they think that's possible. But at the end of the day,
Can I ask you to clarify something you just said? So you said there's no evidence they report these risks to their investors. By that, do you mean these types of risks associated with system upgrades in particular?
correct.
Or, okay, because conceptually,
Problem. Yeah.
I understood FERC to be saying that these types of risks faced by the grid as a whole are accounted for in the ROE analysis, right? And so what we're discussing now is just whether there's a distinct dollar figure on that type of risk borne by system upgrades as opposed to the rest of the TO's
Right.
grid.
Right.
Okay.
And there's nothing to suggest that in general, that the enterprise level of analysis is wrong. That like we need to be looking at particular facilities, that the enterprise level should take care of concerns that the risks that they have generally. And so if they were reporting those to investors, if there were credit rating issues related to this matter, then there would be an urgent need to do something.
But they're fundamentally, I understood the point to be that these risks, whether they're to this portion of the grid,
Yeah.
they're the exact same kind
Yep.
faced by the rest of the grid.
Mhm.
And our enterprise-wide risk analysis looks at, it's not fine-grained, it's a blunt instrument, but you consider these kinds of risks in the ROE analysis. Is
Mhm.
that right?
That's right.
Okay.
Yep.
And what you were acknowledging today essentially is if they could show that the system upgrades, due to the system upgrades or otherwise, those risks are not adequately being compensated, they could make a filing and with more evidence and raise their return on equity.
Right. Right.
Okay. One of their arguments on this point, the Section 206 issue,
Mhm.
is essentially, we bore the burden of showing that this kind of risk is not compensated for, but we met that burden with Novak's testimony.
Mhm.
And he does say the determination of the authorized return is set by reference to the risks associated with investing in the rate base. And then the FERC orders essentially just say, no, it's set as to a whole, but it sounds like on both sides, there are just claims going out. And what's the right way for us to think about the burdens and why shouldn't we be concerned that there isn't a FERC order out there that explains how this works?
Right. So I think under the 206 analysis, their burden was to show that the current system is economically unfair to them. And the way that they chose to define what economic unfairness looks like is that they claim that we have an increment in risk of the same kind we already face. And so to FERC, that looks like a return on equity question. And when it comes to these sort of phrases of what it gets applied to and what it doesn't get applied to, that's where the idea of the contributions and native construction agreements example comes up. You're not entitled to a return on every single facility that happens to be part of your system. As the record here indicates, these are facilities that are transferred over at nominal cost to the utilities. So they didn't put any money into these facilities for them to be built. So why would they be paid for an investment they didn't make? So I think there's a lot of issues related to just basic concepts that this type of theory has to encounter, and that's one of them. And so to make it work, to take into account these potential types of problems within the current framework, this looks like a return on equity issue for the investments they've already made, because that is the profit margin that is at risk when it comes to potential things that can go wrong in the future.
I just have two more questions.
Yeah.
One, there's been discussion of these kinds of risks resulting in actual penalties. I don't remember seeing that argument in the briefing, but if that's true, wouldn't that be now an incurred cost that they could make a filing and make the case they've not been compensated for in their rate, seek an adjustment for that? Or would FERC object to that?
I think it depends on the type of penalty. Penalties aren't necessarily
I see.
recoverable in rates because it sort of depends on the circumstances. My understanding of the
But if it was a more traditional cost, one of the risks here is just failure of system upgrades, right? And
Right.
something breaks, it costs $1 million to fix it. They can make a 3.10 filing to recover that cost.
That's right. I mean, and that is, in our interpretation of that provision, that's what that is for, is to help them make sure that they get into their rates the costs that they actually face in the types of responsibilities that are already assigned to them by the tariff. Not to rearrange responsibilities, but to make sure that they are not left holding an expense that would otherwise be recoverable that just isn't accounted for in their rates. So I think, when you talk about these penalties and examples, it is a long set of testimony here, but we shouldn't confuse, length with on point issues. The types of penalties they are talking about are ones that are generally faced, again, as we've discussed. And I'm not sure that any of these specific examples relate to a system upgrade specific facility failing or resulting in penalties.
And then the last question was actually about the discriminatory rate issue. They argue that the fact that MISO and other operators, the TOs there, are allowed to do this type of funding and they are not, makes this a discriminatory rate. And I want to clarify what exactly FERC's response is, because in the brief, there seems to be maybe a categorical legal argument that disparate rates affecting different regions simply can't ever be discriminatory. Is that really the argument, or is it more of a fact-specific finding?
I think it's a little more fact-specific than that. I think the issue that FERC did reject the principle of the argument that you can look at one rate in isolation and say that just because another region has it, the lack of it in ours must be unjust, unreasonable. The only fact they kind of helped support that notion with is that system upgrades were increasing in their region. And so I think that FERC rejected the principle that you can just look at another region and say, I'll have what they're having. But this is a type of claim they make that is susceptible of evidence that could have been paired with other things. And so I don't think that not only there is that frontline legal issue, there is also just a failure to carry a burden as a normal kind of Section 206 type of case as well.
Thank you.
And looking at,
Did you need to finish with your answer to him, to Judge Garcia?
I was just saying, in Joint Appendix at 100 is where it talks about revenue losses for shareholders.
Sometimes it sounds like this is going back to the 205 issue, when you're telling us what costs mean in 310A.
Yeah.
You're saying costs means investment. It doesn't mean expenses. Am I understanding that to be in the ballpark of your argument?
So reasonably incurred costs would be expenses, in the sense that if you look at the description in paragraph 22 of the rate order, that description, it talks about costs that are recoverable in rates that are just recoverable.
Okay. So if we do think of it as expenses, then imagine I'm running a business and I have 100% likelihood of a $1 expense next year. And I have a 10% likelihood of a $10 million expense next year. The first one is certain, second one, not certain. But isn't the second one a bigger expense?
Well, I don't think that we're talking about particular magnitudes of dollars here. And
I guess why shouldn't I think of the second one as an expense? A 10% likelihood of a $10 million expense. That seems like an expense, and you just told me an expense is a cost.
Well, I think that the rehearing order does explain that costs you incur to mitigate risks or to address risks are costs, like they are recoverable. So if there's something that the transmissioners can point to that they are doing to account for the risks that result in costs, those might be recoverable.
They're saying it's a risk of an expense going forward.
Right.
And they say that's a cost. And if it's a cost, we get to make a 310A filing. And I thought a minute ago you were sort of saying, yeah, an expense and a cost are basically talking about the same thing.
Right. Well, I think the current rate structure allows them to get recovery of things that are operating expenses or capital expenses. So if you can think of your potential cost as going to be one of those two things, and there's an obvious investment responsibility you already have that's tied to this, then it's possible to think of this provision as covering it. The problem is it doesn't relate to actual policy changes of the tariff. And if you look at section 3.03 of the agreement, that hands over all the rate filing responsibility to the system operator, and only this carves it out.
Okay. I think this is my last question.
Sure.
The two concerns that Judge Katsas began with that were kind of captured from arguments made by the petitioner and the intervener. I thought one of your responses to him would be that those are new arguments, raised oral arguments, so we can't consider them. But is that fair? Or were they made in the briefs? Just reiterate it more at oral.
Which specific argument are you referring to?
So remember that
Retroactive
I don't think
rate.
the word retroactive is in briefs, maybe.
So I think that there were things raised in the case about that, but it is not like a specific argument saying that the current system is creating a retroactive rate making problem. I don't know that that was fully developed. I think we're looking at the current economics of the system and whether or not the transmission owners are facing actual economic struggles today.
maybe on rebuttal, I'll ask them. But
Okay.
it seems like if it's not in the blue brief or the intervener, you can't consider it.
I would think so, but that is an issue that has been tossed out in the general scheme, this type of.
Yeah, but I mean, generally speaking, their position is you have to solve the Ameren problem. You have to solve the Ameren problem one way or the other.
Right, although.
B, we prefer a rate-based solution to a return on equity solution, but they made both arguments. I mean, they're seeking relief one way or the other.
Right, but I think the Ameren problem is actual capital attraction. That's the end point that the Ameren case is making. Assuming that the transmission owners there were correct, they were facing a capital attraction problem. There was an opportunity to put in evidence of that here and it just didn't happen. So I think that once you get to the specific facts of these types of cases, that's where you get a full rate determination. And again, Ameren was a failure of the commission to respond to that argument in the first place.
Okay. Anything else?
Thank you.
Okay. Thank you.
Thank you.
Mr. Strauss, good morning.
Good morning, Your Honor. So I'll make sure you can hear me clearly. Scott Strauss for the New York State Public Service Commission. Meeting the goals of New York's 2019 climate law is going to require both new power plants and new transmission facilities to deliver their output. Under participant funding, which has been part of the New York rate design for 20 years, the developer funds the upgrades using the most cost-effective financing available in the marketplace. Now, petitioners are attempting to eliminate it through a Section 205 filing. But they can't do that because they lack the authority to make that filing. What you have is a square peg round hole problem here. Agreement Section 3.10 authorizes Section 205 filings to recover costs that the transmission provider has incurred or to adjust the return applied to investments that the transmission owner has in fact made. Those rights are not implicated here. Petitioners have not identified costs they've incurred or investments that they have in fact made that they can't recover. What they're trying to do, and Judge Garcia, I think you had it right in your questioning earlier, they're trying to use this provision to change the rate design so that they can make additional investments on which they can then earn returns. But they can't get there from here to there. That's why they have to go to Section 206. Now, Section 206 fails because they simply don't have the evidence to support the burden they bear to show that the existing.
So
Yes,
before
sir.
you get to 206, let's just
Sure.
push a little. I understand your argument why they're not talking about costs, but the reservation in the tariff also lets them do a 205 filing to seek a reasonable return on investments related to services under the tariff. And I mean, the commission has moved pretty far today towards saying there may be issues here, but they are related to return on investment.
Correct.
So why isn't this at least a litigable issue on the appropriate return on investment? And they might or might not win their 205 case before FERC, but.
Oh, I think you misunderstand, Your Honor. I agree with you. They have a remedy here. Their remedy is to attempt to seek a return or an increase in their return on investment. I'm not suggesting they can't file a case to change their ROE going forward if they want to do that. What I'm saying is you can't use the 205 route to change the rate design. That's what they're trying to do. They're trying to change the rate design so that they get the right to make investments that they currently cannot make. That's why they're here. They're here because they want the right to make an investment on which they can then earn a return on. So what they've said is we're subject to all of these uncompensated risks. They don't quantify them. They don't actually show any evidence of real financial distress, such as would be necessary to justify that kind of relief. They don't tell you that they're on credit watch. They don't tell you that their credit ratings have gone down. They don't tell you that their borrowing costs have increased or that they can't attract capital. They don't tell you any of those things. And by the way, this case was filed in December of 2021. It has been almost 3 years. If they had evidence during that time.
Ameren did say it would be hard, it would make it harder to attract capital.
Ameren said they were not reaching the merits of those questions. They raised them as issues and sent them back to the commission. The court was very clear, page 880 F3rd 582, that they were not reaching the merits. And the court also said in Ameren that they understood that investors invest on the entire enterprise, not particular portions.
I agree with you that Ameren said we're not reaching the merits, but I think I did understand them to say, though it may still possibly be a just rate to do generator funding, it is going to make it harder to attract capital.
I think where you can link Ameren in this case, which are essentially mirror images. In Ameren, you had transmission owners self-funding in the tariff. There was an effort to dislodge it. In this case, you have participant funding in the tariff. An effort is being made to dislodge it. What links them is evidence. That's what this case is really about. Is there any showing here that these transmission owners are facing real financial distress under the current scheme?
Do you disagree with Commissioner Danley's statement? I'll read it here. While it may be difficult to assess with precision the risk assumed by a transmission owner operating a system upgrade, the one thing we do know is that it is not riskless. It cannot be. Does that seem right?
Might there be a risk in adding facilities to your system? There could be.
And then if there could be, even if there could be, it seems like that almost by definition makes it at least a teeny bit harder to attract investment.
But you have to make a showing to that effect. You have to demonstrate that there's that problem. These transmission owners have made no showing on this record that they are facing any risk attracting capital.
And I'm not saying that this means you lose or that.
No, I get it.
But it does seem like you don't need to make a showing of what seems like a pretty basic economic concept, which is if there's going to be some increase in risk, which is conceded, then it will be somewhat harder to attract investment.
And if you can make that showing, or if it's obvious, then you have a route to change your return. You have a route to try to take, you have a remedy. They are not without a remedy here, just not the one that they're seeking. I'd also tell you that while they're here
What's their remedy?
to seek a change in their return on equity, an attempt to demonstrate that it doesn't.
205.
Through 205. Oh, absolutely.
And they haven't done that in this 205 filing?
They have not. They have sought to change the rate design here to allow them to make investments on which they will earn the existing return on equity. They haven't asked to adjust the return on equity.
I'll check that. You don't think they made an alternative?
Not to my knowledge, no, sir. No, sir. The other thing I want to point out is that while expressing concern here about the risk they are facing, the fact is that the New York climate law will require them to build additional amounts of planned transmission. And far from touting the risks, they are touting the benefits. The transmittal letter to their 205 filing, in this case, that's in the appendix at page 10, refers to the need for there to be a significant expansion of the transmission grid to integrate renewables. I'm sorry, that's at page 8. At page 10, they say they are committed to incorporating clean energy drivers into their transmission capital planning to ensure that their local transmission networks can meet the needs. What this means is that they are going to engage in substantial planned transmission, which they will fund, they will invest in, they will put in an investment base, and they will earn a return on. And I call the court's attention to the brief of my colleague from the American Clean Power Association at page 14. They reference testimony that Petitioner Con Edison informed the Securities and Exchange Commission in 2020 that it had identified $4.5 billion in local transmission investments that would be needed to meet the goals of the climate law. Those investments, to the extent they are planned, they are going to go into rate base. And to the extent that they overhaul the transmission system, which they say in their brief at page 6 is needed, they're going to spend money on investing in facilities to meet the new needs.
Why are those not system upgrades that the generators are responsible for?
Because they're going to plan the system to meet the needs in advance. If they do it correctly, they do their job right, and they right-size the system correctly, the need for these interconnection-related upgrades should be minimized. I also want to point out, council mentioned during the argument something about a 1,200% increase in interconnection upgrades or requests or something along those lines. I note that there's a graph in their brief at page 7, I believe, that shows that there was something like $1.2 billion in interconnection funded upgrades in 2019. In fact, FERC had asked them in a deficiency letter to say that was an estimated number. What was the final number? The final number was actually about a quarter of that, or $300 million. That's not an insignificant number, but if you look at the overall picture of their risk profile, as FERC did, there's no evidence to indicate that their return is too low or they otherwise are facing financial distress.
So a quick question about Commissioner Danley.
About Commissioner Danley himself?
Yeah, and
Okay.
whether his opinion
Oh, his opinion, yeah.
and whether, because I think, just wanted you to tell me if this is right, because I think your fundamental point is that perhaps there is a marginal risk that goes up, and perhaps then they should be able to increase their return on investment.
They could make that showing.
But most importantly, that's not what they're asking for.
Exactly,
They're asking for a change to the rule to ask for a new investment.
exactly.
And Danley did not say he thought they should be able to do that.
Right, right. And remember that what we're talking about here is essentially a technical matter of electricity rate design, which the Supreme Court has said in FERC v. EPSA is something on which the commission gets a great deal of deference. Thank you, Your Honors.
Thank you, Council. Good morning. Is it Tabak?
Tabak, Your Honor.
Tabak. Mr. Tabak.
Good morning, Your Honors. May it please the court. Gabriel Tabak on behalf of the generator interveners. Your Honors, I wanted to briefly hit 2 points that reinforce those that have already come forward in the discussion today, both of which are linked to what the New York transmission owners are actually disclosing to their investors, and because of that, speak to whether they have met their burden of proof under Section 206. The first is that the disclosures to investors of any risks related to system upgrades by the transmission owners are only at a generalized level. I would refer the court to the testimony of our witness, Michael Goggin, beginning at JA 513. None of the examples that the transmission owners have cited in their testimony actually have anything to do with a system upgrade specifically. These are examples of broad categories of risks that utilities in New York or elsewhere may have been responsible for, but none of them are specifically linked to the category of facility that they are before the court discussing today. It's really a generalized risk faced by the overall enterprise. The second point, which is related to that, is that the transmission system operates as an integrated whole. The transmission owners and the New York Independent System Operator have the responsibility of running the whole system from the lower voltage facilities to the higher voltage facilities, from Niagara Falls to New York City, as an integrated whole. But from a capital and rate base perspective, it's actually more of a quilt. There can be
more of
a quilt. There are different aspects of the system that can operate with different rates of return. The commission cited one in their brief, which are contributions in aid of construction, which the commission has always held that if a utility receives a contribution, maybe of land from a municipality to help build a substation or transmission line, that is not included in the rate base. There could be network upgrades that generators fund. There could be fully depreciated assets, which are no longer included in rate base after they're depreciated. And as my colleague from New York indicated, there can be large scale planned transmission. Each of those things may have a different role in the capital structure and whether they're included in the rate base, which really means that the relevant discussion here is regarding what the overall enterprise risk profile is. The ROE, that, as the commission rightly noted, is the way that stitches together those pieces of the quilt and assesses whether the enterprise as a whole is healthy. And I think to Judge Walker's questions regarding Ameren, I think the court's concern there was whether, I guess, if I'm stretching the metaphor too far, one piece of that quilt could become oversized and skew it. And that, again, circles back to the Section 206 burden here, and the fact that the transmission owners have not disclosed any material risk. And indeed, as my colleague from New York noted, the only reference to the state policy drivers that are pushing forward the major grid changes in New York, the only references that are expressly made to investors here are regarding the investment opportunities that occur from this large planned transmission. I'd refer the court there to JA 518 and 519 and JA 491. In our protest before FERC, we identified two of the New York transmission owners. I believe one of them was the $4.5 billion, another was another $400 billion. So $4.9 billion that is being disclosed to investors from the same source that is spurring the need for network upgrades in New York. But the network upgrades are not specifically mentioned at all. They are only rolled into these generalized categories of risk. For those reasons, the commission rightly found that petitioners had not met their Section 206 burden.
Thank you, counsel.
Thank you, Your Honors.
Mr. Tompkins, we'll give you 3 minutes.
Thank you, Your Honor. Judge Garcia, to go back to the question you asked about the record evidence, Mr. Novak's testimony that the current ROE doesn't account for these system upgrade risk. I think you found it because you quoted something when Mr. Perkins was here, but it is Joint Appendix 649 through 650. Judge Walker, you asked Mr. Perkins about FERC's precedent for including such assets and or such risk in ROE. In response to that, I would just like to read this quote. Quote, the commission in the Ameren remand orders found that transmission owners do, in fact, have at least some uncompensated risk when forced to operate network upgrades paid for through generator funding. This is consistent with the Ameren court's finding that FERC's precedents do not provide compensation for several classes of risk that transmission owners allege will accompany construction and operation of the network upgrade facilities. The existence of such uncompensated risk supports the transmission owner's basic contention that they are entitled to be compensated now for operating the upgrades. That quote is from FERC's brief to this court in the American Clean Power Association case.
It seems like there has been remarkable unanimity today for the proposition that if you think that your rate of return is becoming too low in light of these increased risks that you are forced to bear from generator-funded upgrades, you can seek an adjustment in your rate of return through a 205 filing.
Yes,
Okay.
that's correct.
Now, did your current 205 filing, which is before us, ask for that relief in the alternative?
It asked for an adjustment of the rate, the return on investment. It did not ask to adjust the ROE, the return on equity component of that. But it did ask to adjust the rate base.
Rate base only.
Rate base only, which is a component of return on investment.
That seems, at least partially incomplete. It asked for a change in the rules so you could make new investments to increase your rate base.
The only way to change the rate base is to ask to make the new investments. That's the problem here, is that we can't put the existing system upgrades into rate base. We can only do this prospectively. So the only way to change, there are multiple ways, I guess, we could change return on investment. One would be because return on investment is a mathematical formula, right? It's weighted average cost of capital times rate base. So to change the return on investment, we could ask to change one of those components, both of those components. We asked to change the rate base part of that.
But not return on equity.
Not return, we did not ask, because as FERC acknowledged, that was a new concept that came out of their orders in this case. That was not an option that had previously been in any FERC order. But the rate base adjustment is traditionally how these risks are accounted for. As Mr. Perkins said, the system upgrades become part of the transmission system and are just like every other asset, every other facility on that transmission system carrying the same risks. The risk of every other facility is in rate base. And that's why there's this mismatch to put it into put these specific facilities into ROE. And this is a significant problem. In 2019, system upgrades accounted for 7% of the total transmission plant. If all 1.2 billion had been approved, that would eclipse that entire 7%. It would be more than double it. The 300 million that ultimately were implemented in 2019, you increase that percentage by over 2%. I think the 7% was around 900 million in system upgrades. So the 300 million is another 1/3. And that's continued to increase, and we expect it to continue to increase in the future. I'll just end with this. In the Ameren oral argument, when FERC said there was no harm to utilities, Judge Silberman said, this is an attack on the business model. First, you take it finger by finger, and then you take it arm by arm. That's where we are. At this point, the arms are being taken. Thank you, Your Honors.
That was, can I ask a kind of more technical question?
Oh, sure.
That was a very strong, emphatic conclusion, but the two concerns that Judge Katsas raised that I think were inspired by concerns that you and the intervener raised. One was the retroactivity problem. One was this will be cost shifting to the wrong customers problem. Are those identified in your brief and in the intervener for petitioner's brief or not?
I think the concepts are definitely there, but that's a step 2 problem. The issues before this court, in our view, are step 1 problems. In the 205, it's whether we have the filing rights. And then step 2 would be debating whether our proposal was reasonable. The 206, the question is it unjust and reasonable or discriminatory? If so, what's the replacement rate? What's the good solution? I think the retroactivity goes to that question about, is ROE even possible as a solution? We don't think we ever got there, which is why we need to remand to FERC to have that debate.
I appreciate that. And sorry for stepping on your mic drop.
It's okay. Thank you.
Thank you. Case is submitted.
Case number 23-7080 et al. Estate of Jeremy Isadore Levin et al., James Owens et al., appellants versus Wells Fargo Bank N.A. and United States of America. Ms. Smith for the appellants Estate of Jeremy Isadore Levin et al., Ms. Wagner for the appellants James Owens et al., Mr. Huda for the appellee United States of America, Mr. Lucatos for the appellee Wells Fargo N.A.
Good morning. Just for the appellees, just so you know, we're going to hear from the government first and then from Wells Fargo in case the list on the order suggested otherwise. been in those seats, you know, with the time ticking down, worrying when I have to get up. So Wells Fargo will be last. The time limits will be as established. Ms. Smith.
Good morning, Your Honors. May it please the court, Suzelle Smith for the Levins. So I'm back for the second time. Let's start. Since I have limited time, I'm really going to compress this and do speed chess here. One thing that everyone agrees on in this case, everybody, is that what we have here are originally frozen or blocked assets, frozen by executive orders, regulations, IEEPA, in October of 2019. Now, I am gonna, and also everybody agrees that TRIA, T-R-I-A, the terrorist statute, is implicated by the fact of the freezing of these Iranian assets in 2019. Now, I'm going to paraphrase the government, but the government sets out the issue as the federal district court lacked jurisdiction under TRIA to issue the Levin writs because the specific OFAC license issued to DOJ here unblocked the assets which are still being held at Wells Fargo in a blocked account. The OFAC license at issue here did not unblock these assets, and it could not. First of all,
That turns on whether or not the assets are still frozen, right?
yes, Your Honor, and whether
That's an undefined term. So we default to ordinary meaning and usage
so for the term frozen, Your
for
Honor.
the term frozen.
So OFAC refers to blocked assets, then it defines blocked assets as
Seized or frozen, and those are undefined.
And this is the first time that the argument has been made by the government or anybody else that blocked assets are not frozen when they're blocked under IEEPA and OFAC regulations. But we spent some time in our reply brief dealing with the fact that blocked assets and frozen assets are used as equivalents and as synonyms in the OFAC regulations, in the case law, and there's no authority that blocked assets under the IEPPA and the regulations in the OFAC
I'm sorry,
license.
blocked asset is a defined term,
Yes,
either seized or frozen.
correct.
Everyone seems to agree the assets weren't seized.
I disagree, and we spent some time in the brief
Right.
on seizure.
Let's assume, I think, your argument, they have to be one or the other,
They can be seized and
seized or frozen. Or
they can be seized and frozen.
I think your frozen argument
Okay, but
is
let's
stronger than your seized. So let's
deal with frozen.
let's deal with frozen. Undefined term. So we default to ordinary English usage. And I can imagine two plausible meanings of frozen in the phrase frozen assets. One is, can you easily convert the assets into cash? And that's a good one for you. And you win if that's what that means. But I can imagine another one. I mean, frozen, a stronger sense of like absolute zero frozen, like no one can do anything with the assets. And I'm not sure why that's wrong. And if that's the right way of thinking about frozen, maybe you have some difficulty because of the license.
So, Your Honor, one of the reasons we spent a great deal of time going over frozen and blocked and their equivalencies is that the United States Supreme Court, the OFAC regulations, every source you can look at in the context, which is what this court needs to look at. We're not talking about frozen peas here. We're talking about terrorist assets that have been blocked and frozen under congressional law, under executive order, and under the regulation. But the reason that frozen can't mean cannot be dealt with at all is that if it meant cannot be dealt with at all, then the government couldn't come in and get a license to deal with these assets under TRIA to operate and do what it wants to do, which is pursue its forfeiture case. the Levins as victims under case law and binding authority, this circuit.
Why is that? Why is that true? They were frozen. They were frozen by operation of IEPA and or the blocking order. And government came in and got a license, which might or might not have unfrozen.
So first they're frozen. I think we agree. First they're frozen. Now the question for the court is, when the license to litigate was issued by TRIA, sorry, by too many initials here, by OFAC. When the license was issued, did that license unblock the assets, or was that license legitimate to do anything? If the assets are blocked and frozen, both the government and the victim and the victims can do different things to try to collect on those assets. One thing the government can do and must do is go to OFAC and ask for a license to litigate, to come to court to try to make its forfeiture claim. And if you look at the OFAC license itself, that is exactly what it does. And the OFAC's license, Your Honor, refers multiple times to the blocked assets. The OFAC license doesn't say these are now unfrozen or unblocked. The OFAC license doesn't say that the government can go to the district court under the Forfeiture Act and receive those assets. What it says is this is not a transfer. If you look carefully at the license itself, it says this is not a transfer. This is not a final order. What this is permission for the government to try to affect a turnover, which is not, of course, what the victims have to do. We don't have to go to OFAC.
So section 1A of the license does say in an unconditional way that the United States, the DOJ and other federal agencies are authorized to engage in all transactions necessary and ordinarily incident to affect the forfeiture of the funds. So I think the government says that is an affirmative authorization to deal in the funds, and that before this license issued, nobody had any authorization to deal in the funds. And you should regard that as unfreezing the assets. Why is that wrong?
So the government's position is any OFAC license, not just this one, but any OFAC license that's obtained unfreezes and unblocks the assets. That's the government position.
Because it authorizes the government to deal in the assets.
The government actually says any license, not just the one that we're dealing with now, but let me deal with the one that we're dealing with now. It specifically says authorized to effect the forfeiture in blocked funds. It doesn't say these funds are now unblocked or unfrozen, Your Honor. It says to effect a turnover. And then it goes on to say further down that the only way you get authority to actually receive those funds or to change the status, which are still held in Wells Fargo. Wells Fargo didn't pay them out to the government. It's conditional on coming to court and getting a valid final forfeiture order. And other words in the license say, this license is conditioned on receiving such a valid forfeiture order from the district court. So the government doesn't have what it would need to actually move the possession of the funds through a forfeiture order to the government. So the government is faced with continued blocked funds and frozen funds, no authority that they've become unfrozen or thawed out because of this conditional license. And there's no case cited by the government that such a conditional license as this would unfreeze or unblock. There's no case that says
About
that.
Holy Land.
So all the cases that are cited by the government, Your Honors, they are, first of all, from other circuits, but they're old cases, and they're old cases which don't deal with the issue before the court today. In some of the Holy Land, I think there was no judgment. We have a judgment. We're already ahead of the government, Your Honors, in the sense that we have a judgment against Iran, and we're just trying to collect. The government's trying to get started, the forfeiture action, under different theories. We don't have to prove that the assets were used. We just have to prove that they were property of. But the government is back in line, and the district court held that it did not have jurisdiction to issue the writs in our case because this forfeiture action, this forfeiture license, not the filing, but the license takes those assets out from under TRIA's notwithstanding language and the shall provision that blocked assets, frozen assets shall be available. There just isn't any authority and no rational support for
Does it
that.
matter whether the funds were blocked when you moved for writ of attachment? Or does it matter whether the funds are blocked now?
It matters whether the funds are blocked now, certainly, Your Honor. When the funds are blocked and you get your judgment, in every case over the past 40 years where we've been dealing with terrorist collection of judgments, what matters is, are the funds blocked now? So can you come into court and go and petition the court under TRIA? So there's no question here. These funds are blocked now and weren't unfrozen. So if Your Honors rule appropriately and correctly, as we think you should, that nothing unfroze these, including this, and it couldn't under TRIA's notwithstanding language, then we're back to court with a valid writ.
Thank you. We'll give you some rebuttal.
Thank you.
Ms. Wagner, your turn.
May it please the court, Jessica Wagner for the Owens, Mawilla, and Kalika appellants. I'd like to reserve 2 minutes for rebuttal. I want to start by addressing this point about whether the funds are still frozen and blocked for purposes of TRIA, and then discuss the prior exclusive jurisdiction doctrine. So beginning with that first point, the government cannot contest that today, no one, not Iran, not Crystal Holdings, not Wells Fargo, and not even the government is able to transact in the funds. The funds were blocked in an order issued under IEPA, and TRIA defines a blocked asset as an asset that is frozen under IEPA. Here, the funds unquestionably meet that definition.
May I ask you the question that I asked Ms. Smith? Are we supposed to figure out whether the funds are blocked now, or are we supposed to figure out whether they were blocked when you moved for writ of attachment?
I don't think that the answer to that question matters because I think they were blocked both at the time of attachment and they are blocked now. But if I had to pick one, I would say assess it at the time of attachment. And let me.
Why is that?
Why at the time of attachment?
Why is that the time that matters? Yeah.
Yes. So if you look at the text of TRIA, it says first it defines a blocked asset as an asset that is frozen under IEPA. But then it says that licensed assets are not included within the definition of blocked asset where the license was specifically required by a statute other than IEPA. And so the text of TRIA illustrates that where assets are blocked under IEPA, but then a license is issued under IEPA, the funds still qualify as blocked assets for purposes of TRIA. That's why I think you should look at the time, at the initial time. But let me address why the funds are still blocked today, and can be no question about that.
From whose perspective do we consider whether the assets are frozen? It's from the government's perspective or from Wells Fargo's perspective?
I think that the key perspective, Your Honor, is neither of those parties. It's Iran, because TRIA says that you're attaching blocked assets of a state sponsor of terrorism. So the key is whether the assets are blocked as to the state sponsor of terrorism, which is Iran. But again, the assets here are blocked both as to Wells Fargo and as to the government. Let me talk about the actual forfeiture.
Much more clear. I take your point about Iran, but what I was thinking is the block is much clearer as to Wells Fargo, which can't do anything with them unless and until they get a forfeiture order. And then there's one and only one thing they can do, just hand them over to the government. A little less clear as to the government. Their position is there are these assets out there. Someone else owns them. The government is proceeding with an adjudication to transfer ownership, and they're doing that. And that's sort of what they would do even without a blocking order. So from their perspective, seems like there's been a significant thaw.
So I disagree with that, Your Honor, respectfully, because that's not what the license says. So if you look at the terms of the license, and this is at JA 402, it is a limited conditional future license. Now, again, the government's own regulations say that that licenses can remove blocking prohibitions, but only to the extent specifically stated by the terms. We have to look directly at the terms of the license. And the license here authorizes the government to take possession and ownership of the funds from Wells Fargo only after it has furnished a valid forfeiture order to Wells Fargo. Here, the government is far from having a valid order of forfeiture. And so the government cannot do anything with the
Can I
funds
ask the
today.
question that I asked before, which is, that's certainly true as to 1B, but for some reason, and I'm genuinely mystified by this, 1A is not conditional on securing a forfeiture order. And it's unclear to me what, if anything, 1A authorizes. So can you explain to me why the government might say 1A is not conditional, so we can transact in the funds now? What's the answer to that?
I mean, 1A is just, I think, a general statement that says the government can proceed with the forfeiture proceeding. But again, if the government had the funds already, that would be different. But because the funds are currently held at Wells Fargo, and Wells Fargo is not authorized to do anything with them until we get to 1B, the government cannot do anything with the funds under the terms of the license. I think it's also instructive here, Your Honor, if you look at JA 287 to 288, which is where the government requested the license, and it was to perfect forfeiture. It's very clear in the request for the license that it's asking for a license authorizing it to take possession of the funds once it completes this forfeiture process. So I think you should look at that to inform the license itself. But again, the 1A says it is authorized to engage in transactions necessary to effect the forfeiture, but there's nothing that it can do because the funds are at Wells Fargo. Wells Fargo is not authorized to release them to the government until that condition in 1B is satisfied. So today, the government can't move the funds. But again, I think the key party is not even the government, it's Iran. And I think that that's the point about frozen, going back to some of your questions, Judge Katsas. I don't think it matters because here the funds are frozen as to all parties. But from TRIA's perspective, the key is whether the funds are frozen as to Iran. There's nothing in the statute that says it has to be frozen in every aspect. And I think it would be sort of absurd to have a rule to that effect, especially when you're talking about the government, because the government is the one who blocks the funds in the first place. The government always has inherent authority and discretion to remove the funds. There's numerous cases the Supreme Court has talked about, how.
Fair point, except this whole scheme creates this weird distinction between OFAC and DOJ in its capacity seeking the forfeiture. It's not a unitary executive for that purpose.
I mean, I would still argue that they're all under the executive branch, Your Honor. But again,
Me too, but that's not how it works.
Be that as it may, the key is it doesn't even really matter because the government can't do anything with the funds here. I do want to just briefly address the other circuit court cases that have dealt with licenses. So this is
before you, I do want to hear that, but just very briefly, is it your understanding that essentially in every civil forfeiture proceeding of this kind, the government needs an OFAC license that looks something like this to even start the process?
So I would say in any instance where the funds are blocked, right? Obviously, there's forfeiture proceedings where the funds are not blocked.
Yes, that's what I mean.
Because, and this is the way that the scheme works.
Yeah.
When Judge Mannion explains this very well in his opinion in the RJ O'Brien decision, but when funds are blocked under IEPA, in order to be able to do anything with them under IEPA, the way that this regime works, the government has to request a license under IEPA. And that's why, we see the government here requesting a license once it initiated the forfeiture proceeding. If it didn't think it needed one, it wouldn't have done that in the first place. So turning
to the cases, I'll let you dive into them, but my sense was that your position is fully reconcilable with Rubin and Weinstein, but not reconcilable with Holy Land and O'Brien. In order for you to win on this point, we need to create a 1-2 split.
So I would respectfully disagree. I think that there is a way for you to rule in our favor and reconcile all of these decisions. So I'll start by talking.
Give me that one, or
yes.
Do it whatever order you want. But
I'll start by talking about those two cases that you think are not reconcilable. And I think here's the key distinction. In neither of those cases were the courts dealing with the text of the specific license here. In Holy Land, the Fifth Circuit, and in RJ O'Brien, the Seventh Circuit, there was nothing to indicate that either case involved a conditional limited forfeiture license like we have here. In R.J. O'Brien, the text of the license was not even in the record or before the court. All they had was a stipulation regarding it. And neither the parties, I went back and looked through the briefs in this case, neither the parties or the court gave any indication or raised any argument that we had these limited conditional terms
I
here.
thought in Holy Land, I'll go back and reread it, but I thought the gist of it was there's a blocking order and then there's a license allowing the government to pursue a forfeiture. Is that not right?
I think that license there also authorized the government to pursue restraining orders, at least from what the court says in the quoting it, but we don't have anything else about it. And we don't have the limitations that we have here, that the government can't actually do anything with the funds, can't take possession of the funds until it obtains a final order of forfeiture. There is no term like that discussed in any of these cases raised by the parties or discussed by the courts. And I think another key point is the parties in both cases did not press the statutory argument that I referenced earlier, which is that the license was required by IEPA, and because it was required by IEPA, by definition, it couldn't unblock the funds. In Holy Land, the Fifth Circuit didn't address that argument at all. And in R.J. O'Brien, the Seventh Circuit held that that issue was waived. So because we're dealing with a different license, and because we have repeatedly before the district court and before this court raised these specific limited conditional terms of the license, as well as the fact that the license, because was required by IEPA, because the funds were blocked under IEPA, I think there's a way that you can rule in our favor without creating a circuit split with those decisions.
And do you think Judge Mannion was overreading Holy Land? I took him to be saying that Holy Land establishes what the government says here, but was wrongly decided.
I mean, I do think that there were aspects of Holy Land that were wrongly decided, but I don't think that this court has to disagree with Holy Land to rule in our favor. So in Holy Land, the Fifth Circuit really guts the notwithstanding clause of TRIA.
How would we do that? One point which I get is to say the statutory issue wasn't addressed, so it's a drive-by. Is there anything else? You think the license was broader?
Again, there is no indication that there were the specific limited conditional terms in those licenses. There was nothing that said that the government could not take possession or ownership of the funds until after it had obtained a valid order of forfeiture. And I guess the other point I would point out is the timelines in those cases were very different. In both Holy Land and in R.J. O'Brien, the government had already obtained licenses and proceeded with their forfeiture actions before the plaintiffs in those cases had even gotten judgments against the state sponsors of terrorism, let alone sought to attach the writs. So in Holy Land, by the time, which involved criminal forfeiture, by the time that the plaintiffs were raising their TRIA argument, they were doing it after the government had already obtained a preliminary order of forfeiture entitling it to the funds. That's completely different. The government doesn't have that here.
Yeah, that's your fallback argument that you got your judgment lien in time. But I'm just trying to focus on the threshold question, whether a license like this unfreezes.
Yeah, and again, I think it can't for the two reasons, because one, the text of TRIA says that it can't. TRIA says that licensed assets are not blocked assets unless the license was specifically required by a statute other than IEPA. Here, the license was required by and issued under IEPA because the funds were blocked by IEPA. So there's a statutory reason why the license can't block the funds. And there's the factual reason that the terms of the license here simply just do not block the funds. Again, you can ask the government, no one today can transact in the funds. To say that they are not blocked would be totally incongruous with the actual facts on the ground.
So I just want to make sure I'm parsing the different arguments correctly. So I think the statutory argument you were just referencing is the one that depends on the exception.
Correct.
But even putting that aside, I understand, and I very much understand the license-specific argument. You have another argument that the word frozen, before you look at the exception,
Yes.
it just means from Iran's perspective, not the US's perspective. And that argument may be right, but that's the argument that would be inconsistent, I think, with the Fifth and Seventh Circuits, right? That frozen is just from the perspective of the blocked entity.
Yes, I don't know that they got into that argument in those cases. But I mean, again, I was trying to outline a path for how you could rule in our favor without having to disagree with those circuits. I think you could
Yeah.
easily reach
position
that
is
argument.
certainly the broadest
Yes.
position.
And I think it's right, just because, again, this is about TRIA. It's about whether the assets are blocked as to the state sponsor of terrorism we're trying to attach. It's not really about whether the government can transact them. I mean, Dames and Moore, the Supreme Court says that blocked assets are usually retained for the president's discretion. So whether the government can move them shouldn't really be relevant to the definition of whether they're blocked as to a state sponsor of terrorism.
I wonder what's wrong with this understanding of the civil forfeiture statute and TRIA. So as I understand it, the civil forfeiture statute says when the US can seize assets, sort of like a sword. When can the US go get something? And sovereign immunity, normally something of a shield for foreign countries. TRIA and FSIA take away that shield to provide immunity. That doesn't change anything about the sword. It doesn't change anything about what the civil forfeiture statute says the US can and can't do. And if we look at it that way, they're not in conflict. And so the notwithstanding language in TRIA doesn't do any work to upset what the civil forfeiture statute says, which is these funds are in the custody of the Attorney General.
So the funds, again, are not actually in the custody of the Attorney General. They're in the custody of Wells Fargo.
I think that's only if we think the civil forfeiture statute in 981C doesn't apply.
No, that is the actual facts of the record. They are held at Wells Fargo's accounts. The government, again, has not been able to take possession or ownership of them, and it's not authorized to do so by the terms of the license. But going to the TRIA notwithstanding clause point, which I think was the heart of your question, TRIA's notwithstanding clause is very clear. Victims of terrorism shall be able to attach blocked assets of state sponsors of terrorism, notwithstanding any other provision of law. Congress enacted that provision after victims had been thwarted over and over, usually by the executive, from being able to go after blocked assets and obtain, satisfy their judgments.
If I may interrupt, I agree with everything you just said there, but I thought that what the executive had done to thwart was in part invoking the FSIA, its ability under the FSIA to cancel out what the text that later Congress insisted on with TRIA.
You're exactly right. That is one of the many things. I think that was the specific thing that prompted TRIA, but there have been a number of cases and issues prior to that point. But yes, the FSA has a provision that allows victims to attach blocked assets. It allowed the president to waive that provision. The president did so almost immediately. And then Congress said, no, we're passing TRIA, notwithstanding any of the provision of law, does not have that broad presidential waiver provision. And so TRIA is very clear that victims of terrorism need to be able to have a substantive cause of action to attach blocked assets. And the government says, well, you can do this in the context of the forfeiture statute, just bring your claims there. But they're being duplicitous in that respect, because they have already previewed for us their position, which is that in order to have standing in the forfeiture action, you have to have a valid writ of attachment. And they point to, and this court has not addressed it to my knowledge, but other courts have held that judgment creditors have to have, unsecured judgment creditors don't have standing in a forfeiture action. To have standing, you have to have a valid lien or attachment. And so the government is essentially saying lose-lose. You can't have your writ actions to get you the writ that gives you standing, and then you must bring your claims in the forfeiture action. We're going to say you don't have standing because you don't have a writ.
I follow that, and I take the point about sort of the history and the purpose, the history behind TRIA and the purpose of TRIA. But what about TRIA's text should make me think it's a priority rule, it's a substantive rule about who gets a terrorist state's money, as opposed to just saying the terrorist state doesn't get to keep its money?
I think the notwithstanding of the provision law is hard. I mean, this court said in Crowley that it's harder to imagine a clear statement than notwithstanding any other provision of law. And that means that any other provision of law that would conflict and get in the way of our ability to bring a substantive cause of action against the assets, TRIA overrides that.
But it seems like it could instead mean notwithstanding any law that gets in the way of Iran being immune. And and I agree with you. There's no other, let's say there was another statute out there that said Iran is not immune. That notwithstanding language would be very powerful in TRIA, and we would read TRIA to preempt a statute, or in this case, a background principle of sovereign immunity, or the sovereign immunity. But it seems like all it does is just say, notwithstanding anything that might make Iran immune, Iran is not immune. Now that we've established that, let's see who gets to take Iran's money. And that question seems like it's answered by the civil forfeiture statute.
So I respectfully disagree with that reading, Your Honor, for two reasons. First, I think the text of the statute is incredibly broad. Notwithstanding any other provision of law, it doesn't say it's not limited in any way to immunity. And then again, we go back to the history. Congress enacted TRIA after the executive branch waived this provision of the FSIA that allowed victims to attach Black funds. Congress is very clear, if you go back to legislative history, and some of the cases discuss this, that they were trying to ensure that victims of terrorism had a way to satisfy their judgments and were able to attach blocked assets. Nothing that I'm aware of would indicate that they were trying to limit it to immunities, notwithstanding any other provision of substantive law, here the forfeiture statute. The other third point I would add is the district court and the government have essentially conceded that. I think it's very interesting when in the FSIA context, which was the other alternative basis for writs, both the government and then the district court accepted this argument, argued that the forfeiture statute's exclusive jurisdiction provision should apply. They don't make that argument in the context of TRIA because they recognize that TRIA notwithstanding clause overrides the substantive statute.
I am grateful and I appreciate that. If I could just one question on the commerce in the United States question, the commercial activity in the United States question. Here we have a foreign seller using a foreign bank, a foreign buyer using a foreign bank. Do you have any judicial precedent where those are the facts and the court says this is commercial activity in the United States?
So I think the key is that the funds came through the United States. That's how the United States got involved. This was a commercial transaction.
But I understand. I think that may or may not be a winning argument. I'm just wondering if any court has dealt with those facts. Funds coming through the United States, but foreign seller, foreign buyer, foreign seller chooses a foreign bank, foreign buyer chooses a foreign bank. And the court says, well, because the funds came through an intermediate US bank, it's commercial activity in the United States. You might still win even if a court hasn't said this already. I'm just wondering if a court has said this already.
I'm not aware of a court that has said that already. I can go back and think, but I'm not aware of anything off the top of my head. I just would reiterate that the key is that it was commercial activity that was coming through the United States. If it was all overseas, we would not be here. We're here because it's in the United States.
Is the priority question before us? So I had thought Judge Boasberg's reasons for rejecting your TRIA argument were number one, unfreezing, and number two, prior exclusive jurisdiction.
Yes.
Neither of those really speak to the question of what's going to happen when you fight with the government and with the other claimants to figure out who gets how much of this pot of money.
So I think, again, that TRIA is notwithstanding any other provision of law clause answers that question, certainly as to the government.
But the question about how TRIA does or doesn't interact with the civil forfeiture statute was not, did Judge Boasberg address that?
He certainly addressed the scope of the notwithstanding clause when he was talking about the prior exclusive jurisdiction doctrine. Again, when he talked about the FSIA basis for writs, which I was talking about earlier, he noted that there wouldn't be the notwithstanding argument that there is in the TRIA context for those. I think that he did address that. I mean, ultimately,
he certainly addressed it as to prior exclusive jurisdiction.
Yes.
But we might resolve that issue in your favor without getting into anything that decides the question of how TRIA does or doesn't interact with the civil forfeiture statute.
Yes. I mean, I think this court can certainly reserve that question for the future case. And again, once we have valid writs, which we would ask the
Remand-
court to
remand
rest.
in this case.
Exactly, Your
Shouldn't
Honor.
come up.
Because then that will be the question, because the forfeiture action we have, once we got our writs, we intervened in the forfeiture action and raised the claim where we started our writs because we had standing based on those writs. So I think that that could be a question in the future. I mean, I would say that the court could simply say now that notwithstanding any of the provision of law necessarily overrides the forfeiture statute, but it can easily reserve that question for a future day. I do want to just speak briefly to the prior exclusive jurisdiction doctrine, since we haven't talked about that. 3 points here. Yes, Your Honor. First, the doctrine was never designed to put litigants out of court. It is supposed to be a procedural rule of form selection, not a substantive rule of priority. Neither the government nor the district court were able to identify a single case extending the doctrine to cases before the same court, let alone before the same judge. Second, to the extent that the rationale of the doctrine, judicial economy and efficiency, had any purchase here, that rationale was fully satisfied when Judge Bates transferred the actions to Chief Judge Boasberg. And notably, in their motion to reassign the writs, the government raised the prior exclusive jurisdiction doctrine. They said they were not asking for writs to be barred under that doctrine, but that the rationale of the doctrine should inform the justifications for transfer. In his opinion, Judge Bates cited the doctrine and the government's invocation of it, and again, without formally applying the doctrine, said that the interest served by the doctrine informed his view that that reassignment was the most efficient, orderly way to resolve the dispute. And so then once the cases were before Chief Judge Boasberg, even the spirit of the doctrine was no longer an issue and it was fully satisfied.
We understand.
Okay.
We'll give you some time on.
Thank you, Your Honor.
All right, we'll hear from the government.
Good morning, Your Honor. Brian Hudak from the U.S. Attorney's Office on behalf of the United States. May it please the court. The parties return to this court again in these collection proceedings, which were filed against funds after the government instituted its forfeiture action with an eye to seeding the Victims' Compensation Fund for terrorist victims. The forfeiture court exercised in rem jurisdiction over them in that forfeiture case. On the first trip to this court, the court answered a very narrow question. Did Iran have an attachable property interest in funds blocked mid-transfer under TRIO? And answered that question in the affirmative. On this appeal, the creditors asked this court to make much broader holdings, which will likely create chaos in this area of the law and risk unintended consequences in other cases. In contrast, the government asked the court to affirm on very narrow grounds that promotes uniformity in the law. I'll start first with the prior exclusive jurisdiction doctrine. The government agrees with Wells Fargo that the court should hold that that doctrine applies here, which resolves both the TRIA and the Foreign Sovereign Immunities Act claims. Whichever proceeding first exercises in rem, quasi-in rem jurisdiction over the property, that exercise is exclusive until that suit reaches finality. It secures predictability for financial institutions and neutral holders of disputed property, a chief concern from the Greenbaum panel opinion. It prevents multiple proceedings from...
The prior exclusive jurisdiction doctrine bar different parties from having claims against the same piece of property?
If a court has exercised quasi-in rem or in rem jurisdiction over the piece of property, yes. If we're talking about...
Second claim can't even be litigated.
Without intervening in that suit or seeking to participate in that suit to assert their claim. I mean, typically, you would think of when you just have disputed issues of property.
It goes to competing sovereigns fighting over the same piece of property. It probably goes to competing district courts competing over the same piece of property. It may go to different district judges in the same district competing, but I mean, all that's been solved. Chief Judge Boasberg has the three claims before him.
Sure, Your Honor, but jurisdiction, as this court has routinely held, is measured throughout the proceeding. So it has to be there from the instant the suit is filed, the proceeding is filed, all the way through its lifespan. So when these were filed, they were not filed.
Jurisdictional defects can be cured.
Can't be cured.
They can be cured.
Well, jurisdictional defects at the outside of the case.
Courts transfer, if someone files in a court without jurisdiction, that court can transfer the case to a different court which has jurisdiction.
For personal jurisdiction, but for subject matter jurisdiction, the limitation cannot be waived. It cannot be excused. The court has an independent obligation to raise it on its own accord. These are not, and jurisdiction needs to last throughout the entire proceeding from the very instance it's filed to when cert is denied in the Supreme Court or the Supreme Court issues its opinion. So I don't believe that subject matter jurisdiction defects can be resolved midway through the case and have them be cured. Moreover, if the prior exclusive jurisdiction doctrine, turned.
Suppose they filed today, they file writ of attachment in the DDC and say, please assign this case, or this case must be assigned to Chief Judge Boasberg.
Well,
before the same decision.
Again, I think the cases that we cite talk about suits, and there's a reason for that, because the suits themselves will have substantive law governing the claims in them. The suits will have issues about who can participate in them and who cannot. And those suits are the thing that, adjudicates the property rights of the participants. And so, when we think of a typical, dispute over with an innocent owner who is facing competing claims to the same piece of property.
How, in your view, could these groups of plaintiffs litigated their TRIA and FSIA issues? They filed a separate action. You say this is prior exclusive jurisdiction. They try to intervene before they get the writ of attachment, and you say no standing because you're an unsecured creditor.
Yeah, I think.
And you're just converting this doctrine, which is, at best a front end screen to get everything before one tribunal, at worst a squishy doctrine of comedy, into an absolute priority rule that whoever files first, gets the priority on the competing claims to the assets.
I think when it comes, to answer your first question about how they could have pursued their a TRIA attachment against these assets, if they had done that before the United States filed its forfeiture action, they could have.
Isn't that impossible? The way these work is the only way the public learns is when you file a civil forfeiture action. That's my understanding. Is that incorrect? That's
incorrect. So, there are plenty of TRIA collection actions brought by victim creditors against assets that are blocked here in the United States where they are filed before the United States has sought to forfeit them. So they get information from different sources. The Freedom of Information Act provides information. There is all sorts of information sources that, is my understanding, the creditors use to identify attachable assets, and they go after them. And there are plenty of cases, most of them are in the Southern District, where creditors have sought to attach blocked assets before the United States has instituted forfeiture proceedings.
Suppose they had done that and filed first.
Yes.
Would the prior exclusive jurisdiction bar the United States government from pursuing claims against the same assets?
No, because those proceedings would have reached finality. The writs would have been issued. They would have created judgment liens in the property to be, and the United States, when it would file it.
And then they would execute.
They would execute. Well, the United States would file its forfeiture action, and they would have.
Under your logic, they can't, because their attachment court on this hypo had prior exclusive jurisdiction.
Yeah, if the court continued to consider itself to be exercising jurisdiction over the pieces of property, there would, that would be.
That's how enforcement works, I think, right? You get the writ of attachment on the front end, you litigate whatever enforcement issues are open.
Right.
And then you get the execution order on the back end.
Correct. So, this would go into an area of what is, I think, highly technical law, where we are divining distinctions between quasi-in rem and in rem jurisdiction at that point in time, and we would have to really probe that. This case does not respond, raise those issues, so they're not in the briefs, and it has not been fully developed in this record. I think at a minimum, if they had obtained the writs of attachment, and the government, after they obtained their writs of attachment, filed its forfeiture case, they would have standing in the forfeiture case to say, this is my property. They don't. They didn't come first. They came second, and they can't come and take away the government's forfeiture action, as they both, it's not just a writ of attachment. In their briefs, they set forth what they want to do. They want to execute on these assets and take them for their own. I'm not sure which creditor wants to do that, because if you read the notwithstanding clauses abrogating the prior exclusive jurisdiction doctrine, I don't know how they can then use as a shield that doctrine to be first in time, first in right as a TRIA creditor. The Levin creditors here have 3 different actions against these same funds. And so maybe they go to South Dakota even before the mandate issues in this proceeding and go and say, court, lift the stay, give me the funds. It will create chaos because under their interpretation, there is no limiting principle in the text of the statute that would prevent one TRIA creditor from going to a quicker federal judge who could exercise jurisdiction over the same asset and get a ruling. There's not a limiting principle in the text because the text doesn't talk about this at all. And that is really why the prior exclusive jurisdiction doctrine needs to apply here. Otherwise, you will have chaos in this collection area.
I'm sorry, why is there chaos if there is some mechanism through the prior exclusive jurisdiction doctrine or otherwise to get before one judge all claims against the same piece of property, which has already happened?
Well, but that's not, but that's what happened. That's what happened as far as procedural measures. That was not the outset of the case. And also, if it doesn't apply, what happens to the South Dakota action? What happens to the Southern District of New York action? We sought to
maybe your prior exclusive jurisdiction argument is a lot stronger as to those cases which were filed in different courts than it is to these ones which were filed in the same court and then moved to the same judge.
I understand, Your Honor, but if the doctrine, they haven't cited a single case where the doctrine has been parsed that thinly.
This hasn't come up.
Well, it has come up. I mean, I think we cite in our brief a couple cases where cases were filed in the same courthouse and the doctrine was used to preclude the second time action. So I understand what Your Honor is saying. I understand that, it seems unfair that if the government comes to an asset first, that the TRIA creditors are locked out of that asset to pursue it as a recovery for their compensation. But I think that's the congressional scheme. And it is reinforced by the more recent congressional enactments, which have civil forfeiture being the fundamental ongoing funding mechanism for the compensation fund, where there are 14,000, 19,000 terrorist victims, including the Owens creditors. What they are trying to do here is get the funds for themselves, all 9.9 million of them, and have nothing go to the other victims of terror that are participating in the fund.
I mean, you might be right. There's something in the forfeiture statute that gives you priority over other claimants, even other claimants with terrorism judgments. There'd obviously be a TRIA issue. All I'm suggesting is it would seem that those are issues to be sorted out before, whichever judge or court takes control over that race.
And certainly if the writ's attached, that will be a consideration that Judge Boasberg will have to reach. I mean, one of the questions the panel had for my friends on the other side was, has the priority issue been addressed? It has not. If the writs stick here, we go to the forfeiture action, they have standing to participate, and the government will argue it as a pre-existing forfeiture interest because the government's forfeiture interest arises the instant the funds are subject to forfeiture, and their judgment liens came way after that. But,
And you might win, you might lose, but that doesn't sound like chaos to me.
well, that doesn't sound like chaos for these creditors and the government here. But what if the South Dakota action proceeds and it goes forward and there's a turnover order notwithstanding a forfeiture claim with claimants participating here? What if it goes forward in the Southern District of New York? And Your Honor, on that point, we sought to move to consolidate and transfer the writ proceeding in New York with the writ proceedings here with the Levin plaintiffs. They resisted and the Southern District refused to do that. So it will create multiple forums exercising multiple perhaps incompatible orders to the same piece of property, which is a concern not just for the United States and its forfeiture efforts, but it is for Wells Fargo, as they expressed in their briefs, and the Greenbaum opinion expressed the number one concern in this area should be, not the number one concern, but a paramount concern in this area should be the risk of incompatible judgments to neutral holders of the property.
Unless my colleagues have questions, you want to move on to TRIA?
Sure. So we talked a little bit about the license. My friends on the other side say it's a very limited conditional license. It is not. Section 1A of the license permits the United States to take any actions ordinary and incident to the forfeiture of the property here. That includes, in the United States' mind, its ability to seize the property and take actual physical possession of it. It hasn't, in order to have the creditors be able to vet their issues, because once the United States takes possession of it, there is sovereign immunity that protects it from attachment. The 1B provision authorizes transactions on behalf of the bank. So the bank can voluntarily surrender the funds to the United States under 1B once there is a final or a forfeiture. It doesn't speak to what the United States can do through its seizure powers by going and seizing and taking custody of the funds and engaging in transactions, ordinary and incident thereto, to promote the forfeiture of the funds.
Bank has possession over the funds right now,
That is correct.
and the bank can't do anything with the funds. It can't give them to Iran. It can't give them to, I forgot the name of the entities in the commercial transaction.
Right.
It can't even give them to the United States right now.
It could give them, well, the United States could take them, I would say, because the United States could seize and take possession of them under its forfeiture.
I mean, if Wells Fargo thinks, gosh, this is a mess, we're racking up these legal fees, we just want to be out of this. Here, United States, take the funds. I didn't think they could do that.
I think if they were to express that to us, we would issue a seizure order and take the funds.
I mean, maybe, but it's sure just whether you think of this from the perspective of the bank or even Iran.
I think what we think
Seems
of,
like on any colloquial understanding, these funds are still frozen.
right, I think that we would take the same understanding as the 7th and 5th Circuits in R.J. O'Brien and Holy Land, which is if once there is a permissible use for the funds, they are no longer frozen as used in the statute. And here, the permissible use is for the government.
But
to
what's the
forfeit.
affirmative reason for that, right? I think at least there's a seemingly compelling story that the fundamental nature of an IEPA order is to block assets of the designated foreign entities from those entities. And whatever else has happened, that's still true. And so I think that's why it feels a little bit odd to say these are unfrozen or unblocked when they are blocked from the very person the order is, the primary purpose of the order is to block them from.
Sure, and I think my response to that would be best illustrated in a hypothetical that's not really a hypothetical because this occurred in another forfeiture case recently in district court. The government seized under IEPA and other authorities weapons that it identified as belonging to Iran in the Mediterranean. It then sought to forfeit those assets and at the same time obtained an OFAC warrant for the United States to transfer them to support fighters in the Ukraine. At no point in time, simply because Iran couldn't get back their weapons, would we ever say that those are frozen once the government was able to transfer them to others for their use? And if, again, it's all government actors, it's all sovereign actions in that circumstance, but at the same time, I don't think that any TRIA creditor could have come in and said, I'm going to attach these munitions and claim them for myself, even though that the only permissible uses would have been sovereign purposes. And so I think you need to, that's where I think R.J. O'Brien and Holy Land really come from, is that yes, it is a sovereign act, but that doesn't mean it's frozen. That doesn't mean it's immobilized for no use whatsoever. It means that the government is the one that can use it. And I would say if the court finds persuasive the reasoning of the dissent of Judge Mannion in R.J. O'Brien, even his dissent talked about, well, when there's a general license, that certainly unfreezes the assets from the inception. Well, the government has general licenses under the OFAC regulations. They're mentioned in our brief, and they're found at 31 CFR 560.557 and several other places in the OFAC regulations. And they say that all transactions prohibited by this part that are for the conduct of the official business of the United States government by employees, grantees, contractors thereof are authorized. The government obtains its specific forfeiture licenses out of respect for OFAC's regulatory regime and to make sure there are no ongoing specific concerns with the specific piece of property to be identified. But the government also has a general license to carry out its official business with regard to blocked assets. Here, that official business includes seeking to forfeit the funds. And so if you, again, Judge Mannion created this specific license, general license distinction that I don't think necessarily applies, but if you think his logic is more persuasive than the majority in R.J. O'Brien, then the creditors here also fail under that same logic.
I asked Ms. Smith and Ms. Wagner whether, in trying to figure out whether these are blocked funds, we look to whether, whether they were blocked at the time that there was a motion for writ of attachment, or whether we look to whether they are blocked now. What's your position on it?
I think they have to be blocked throughout. And I think that was the holding of R.J. O'Brien. Where it said something along the lines of, and I don't have the quote in front of me, but there is no promise under TRIA that the government will continue to block assets of an actor that will make them available for attachment. And I think that plays out with a plainly simple hypothetical. If, for instance, the United States and Iran normalize relations, enter in a peace agreement, sanctions are dropped tomorrow. Unlikely, but say that happens, and OFAC unblocks all the assets. I don't think Congress intended in those circumstances for creditors of Iran to continue to attach them under TRIA. They may have other avenues. There may be other recompense. I know that this happened when sanctions were lifted against several African countries a couple of years ago. But I don't think in those circumstances, the president unblocking assets that the United States collected against Iran when we were adversaries would continue to allow for their attachment under TRIA necessarily if those relations improve.
And it's your position that they were blocked even before the license? Sorry, that they were unblocked even before the license?
It is our position that they were unfrozen, to use the term of the statute, when the United States filed this forfeiture complaint and it had a license. It had a general license. It got the specific license after the Owens plaintiffs filed a writ of attachment. Certainly.
How does it work if, I get that they were arrested on May 1st, the funds were, and the license issued on July 23rd. Between May 1st and July 23rd, I think the U.S. wasn't allowed to do anything with those funds. Is that correct? It needed a license?
I think what we would say is, yes, we needed to take possession and transact in those funds, to seize them, we would need a license.
So it seems like until the license on July 23rd, they were frozen.
I think that there is a stronger argument that they were frozen, but I think under TRIA, again, if they need to be frozen throughout the proceeding, because they, again,
I understand that, but so let's say that when the motion for a writ of attachment was filed by the Owens plaintiffs on May 22nd, that the court had just granted that on the same day. It seems like maybe the court would have been allowed to do that, because at that point, the funds were still frozen because the license had not issued.
I think there is a stronger argument there. The one caveat.
And then my question, okay, well.
The one caveat I will have is I need to go back and look at when the general license for the United States to conduct its official business was implemented in the regulations.
Understood. Now, so I understand, I think I understand what you're saying. And I guess it seems weird to me that the Owens plaintiffs' ability to get this money depended on whether the district court granted their motion quickly or slowly. Seems like it should have been a motion. Either the motion should have been granted or shouldn't have been granted. And the answer to that ought not depend on whether the district court moved fast.
I think in this circumstance that unique kind of factual wrinkle arises. In most circumstances, and if you look at most of the cases that we have pursued, we have the license in hand at the time of the filing of the forfeiture case. So it presents a kind of a unique factual wrinkle here, given the timing.
We have to decide.
I understand, Your Honor, but I think that if you think that property blocked at the time the writ was issued, and the timing is when the writ was issued, not that it needs to continue to be blocked for them to be able to collect on it under TRIA. If that's your ruling, that we look at it when the writ of attachment was issued.
When the motion was made for it.
When the motion was made or when the actual writ was issued, I don't think there's difference in this case, because I think both occurred before July, at the end of July when we received our license, at least for the.
Motion for writ of attachment granted in this.
Yes, because then we moved to quash.
Moved to quash, okay.
Yeah.
Okay.
So it doesn't apply to the Levin's creditors, obviously, because their writ came much later, including their writs.
We could rule for the Owens plaintiffs, rule against the Levin plaintiff, and it would not wreak chaos
Well,
on
so
the nation.
that would just be for the freeze question. That does not answer the notwithstanding question in the prior exclusive jurisdiction doctrine. And I would just, point to the court as, my friend on the other side has suggested that that's a very broad clause. The holdings from this court contradict that. Just earlier this year in Doe against Taliban, where the court was interpreting the scope of the notwithstanding clause under TRIA, it said that courts have consistently rejected an expansive reading of the text of the TRIA as displacing anything that stands in the way of a particular plaintiff's collecting. So that was the holding of a panel of this court just earlier this summer in Doe. And I think it rejects affirmatively that this is a broad notwithstanding clause that's meant to circumvent all laws, all sources of laws, not even provisions of laws, but including fundamental common law jurisdictional concepts of in rem jurisdiction.
What if I think that go ahead.
I mean, it supersedes something, right? I mean,
Yes.
you've tacitly at least conceded that it, for example, supersedes 981C's exclusive jurisdiction provision that TRIA does. You have not argued.
We have not argued that. We have not conceded that, but we have not argued that in this.
I mean, what would that argument even be? That would be that not even a conflicting statutory provision. Or would you say that does not conflict with anything specific in TRIA?
I think we would adopt the arguments of the court in Holy Land, which said that the notwithstanding clause in TRIA did not circumvent the criminal forfeiture statute and the provisions of the criminal forfeiture statute. It has several pages on that, arguing that the notwithstanding clause is meant to take down barriers to execution, kind of the shield that Judge Walker was talking about earlier, not the sword. It wasn't meant to take away the sword. And the provisions of the criminal forfeiture statute are the sword to parry and strike with, not the shield to deflect blows from the other side. I would also say that the purpose of and the provisions of the law that it clearly does seek to circumvent are the presidential waiver provisions of 28 USC 1610F. And in fact, that's what the Supreme Court said was the purpose of the notwithstanding clause in Alahi. And it was also designed so that the TRIA creditors don't need to obtain an OFAC license themselves to take possession of the property. So it has weight. It just doesn't have the weight to circumvent the government's forfeiture authorities. At least that's our argument here.
The prior exclusive jurisdiction doctrine is some kind of federal common law, and federal statute would preempt federal common law, right?
It could.
It could. And I'm thinking, hear me out, because
Yes, sure.
You think you'll like where I go?
Okay,
We'll see.
good.
981C has the exclusive jurisdiction provision. It seems like it speaks directly to what the federal common law might otherwise have spoken to if it weren't for 981C. In that sense, 981C displaces the prior exclusive jurisdiction common law doctrine, but it displaces it in a way that's pretty good for you. It displaces it in a way that says there's exclusive jurisdiction here, and TRIA's notwithstanding clause doesn't conflict with that for the sword versus shield reason. What's wrong with that?
I think that'd be a perfectly fine holding for this court to reach. I think we approached it a little bit differently in our briefs as saying that that 981C didn't necessarily displace the prior exclusive jurisdiction doctrine because it itself uses the convert jurisdiction thereof, which to us brought forth the soil of MREM jurisdiction with the statutory enactment, as opposed to seeking to displace it clearly, which would be either in the text of the statute or by implication, the need to show an abrogation of common law. But if the court rules that the taking away the shield is what the notwithstanding clause meant to do and not affect 981C, then the government would be happy with that outcome as well.
Any other questions? Okay.
Thank you, Your Honors.
Counsel.
Good morning, Your Honors.
Good morning.
Alex Lucados for Wells Fargo. I think I can be fairly brief. Just obviously as a neutral stakeholder, we're looking for clear rules of the road and not to be whipsawed in between different courts with potentially inconsistent decisions. And I don't think anyone disputes that that's a sort of reasonable goal and also might foster some judicial economy. Respectfully, the resolution that I believe Judge Katsas suggested for the prior exclusive jurisdiction rule, which would be if you get everyone in front of one judge, that satisfies the concern, would satisfy our concern. We wouldn't have inconsistent, the risk of inconsistent judgments and the like. Without that, I think it's not solved because of South Dakota and New York. If you look at the New York order that came out, it actually says Wells Fargo can't dispose of these assets without further order from the New York court. So we already are potentially ultimately facing some degree of conflict.
From a problem that like no one has put at issue here. I mean, right, the challengers here are just saying the prior exclusive jurisdiction doctrine doesn't apply if the actions are filed in the same court. That doesn't call into question whether it would apply for actions in South Dakota or New York or anywhere else other than DDC.
Obviously, this court can only rule as to DDC. We're hoping that if this court does that, other courts will do the same and not create a circuit split. Sort of like driving politely, you hope that others go along.
We can't find a district court in South Dakota.
Right.
But,
yeah, no, obviously, but we think that if this court makes the rule, then we have a better chance of taking that rule on the road and saying, look, this is how they dealt with it. It makes an awful lot of good sense. And that's why we'd like to see it happen here. Also, within this specific case, if this were to come up again, it would make it mandatory that the solution that happened here, which is let's get everything in front of one judge, is the rule of the road, as opposed to just, fortunately it happened this time. Okay. Thanks.
Anything else? You've got 40 seconds.
No. I think you
Thank
know
you.
where we're coming from. Thank you for considering it.
Right, rebuttal, let's see. Ms. Smith.
Thank you, Your Honor. Just to be clear, the forfeiture statute, not talking about the license, the statute, all the cases, including the district court below, everybody agrees TRIA preempts the statute by its own notwithstanding language, and the cases we cited in our brief from this circuit emphasize that. The cases and the OFAC regs require the government to have a license to litigate or to try to do anything with blocked assets. We're talking about a specific class of blocked assets under the terrorist regulations. To litigate, the government needs a license, and to take possession, the government needs a license. And Judge Garcia, to your point about Section B, if you're litigating but you can't take possession, then that's a condition of the license, so it's conditional. The only reason the victims don't need a license is because of TRIA. The notwithstanding language of TRIA has been held to mean we don't need a license because it supersedes any license requirements that continue to apply to the government. The license cannot frustrate the purpose of TRIA under the notwithstanding clause, and if it did, it would be void. And this court has ruled, and we cite in our brief, that if an agency acts outside its power and authority, then that would be void, and so the license wouldn't be lawful, but the license does not do that. The license restricts itself to allowing the government to try to bring the forfeiture action. I want to address for 1 second the multiple forum question, because that lands squarely with me. To your point again, Judge Garcia, the victims don't know much about what's going on in the blocked asset world. It's possible to find out. We try to find out. It's difficult. Mostly we get it through the newspapers. But we filed in New York because we didn't know where the assets were. The government complaint didn't say where the assets were. And then we filed in South Dakota when we found out the assets were there, as they still are. The reason for that, not an issue before this court, but there is case law that in determining the priority among the victims, the law of the jurisdiction where the assets are being held is the mechanism if we get to that point. So I just didn't want you to think I was filing cases all over the country for fun. We immediately said that we would stipulate to having the case be in front of the DC court. It doesn't matter. A court should apply the law properly that applies here. If it's a judge in Washington or a judge in South Dakota, it doesn't matter. But ultimately, somebody's got to go to South Dakota because that's where the assets are being held.
Thank you.
Thank you, Your Honor.
A few quick points in rebuttal, Your Honor. First, the government has conceded that the filing of the forfeiture action does not unblock the assets. And I want to just quickly walk the court through that timeline. So on May 1st, as you said, the government filed its forfeiture action. On May 22nd, we moved forward to attachment. On May 25th, Judge Bates granted our motion. We then served those writs on Wells Fargo on June 10th. Later, on July 5th, the government for the first time requested a forfeiture license, which it didn't get until July 23rd. And I would submit that once we had our writs, TRIA's notwithstanding any other provision of law clause should have prevented any further operation of the forfeiture action that would bar our writs. Your Honor suggested that notwithstanding provision could be read narrowly, but again, it says notwithstanding any other provision of law. It doesn't say notwithstanding foreign sovereign immunity. In NLRB versus Southwest General case, the Supreme Court, this is quoting Webster's, says that the word notwithstanding shows which provision prevails in the event of a clash, where there is a clash between our substantive writs, ability to seek writs under attachment, and the forfeiture statute. TRIA has to trump the forfeiture statute. The government is also, I think it's notable, says that it doesn't have possession of the funds, but now it's saying that it could have come in and seize them, but that is simply wrong under the text of the license. The government can't point to anything in the license that authorizes it to go in and seize the funds. It would have to get another license. Rather, Section 2B of the license says that in order for Wells Fargo to relinquish custody, there has to be a valid final order of forfeiture. We don't have a valid final forfeiture. So if the government were to seize the funds and Wells Fargo were to give custody of them to the government, Wells Fargo would then be running afoul of this license. The government would need another license to do that. It cannot possess the funds. And then there is, finally, as we were discussing, there is no clash here. There's no risk of chaos between all these different liens that were all consolidated before Chief Judge Boasberg. The prior exclusive jurisdiction doctrine is supposed to apply between courts. If there was any concern about even different judges, that concern was fully satisfied, and so the court should rule in our favor.
Thank you.
Thank you, Your Honor.
This is submitted.